Okay, good morning, everyone. So I'm David Mills-Daniel, the incoming McDonald Departmental Lecturer in Christian Ethics. So you can tell it's a great pleasure for me to be here for the 10th conference and also to be asked to introduce two eminent speakers for our session, which is entitled Religious Freedom and the Churches in the 21st Century. So delighted to introduce our first speaker, Norman Doe, Professor of Law and Director of the Centre of Law and Religion at Cardiff University, where he established the LLM in Canon Law at Cardiff Law School, which I think we should perhaps be aware is described as the first degree of its type at a British university since the Reformation. Professor Doe has published a number of books in the field of law and religion, not least Law and Religion in Europe for Oxford University Press, and Christian Law, Contemporary Principles for Cambridge University Press. Also have our second speaker, Richard Garnett, Paul J. Shirl and Fort Howard Corporation Professor and Concurrent Professor of Political Science at the University of Notre Dame. Professor Garnett's published widely on constitutional law and debates concerning the role of religious believers and beliefs in politics and society. He's currently working on his Cambridge University Press book, Two There Are, Understanding the Separation of Church and State. So it's my privilege to hand over the stage to Professor Doe.
Thank you very much indeed. And to all the organisers for such a warm and wonderful welcome. The topic, as my colleague there has just said, is religious freedom of the churches in the 21st century. Oh gosh, don't they spin along? And this is the United Kingdom in context. Now, the custom that has developed is for people to read their papers, so I'm going to put my head down and off we go, okay, lightning pace. It's 9:10, so I've got about till 20 to 10. Just before. Okay, the usual focus for debate about the right of churches to religious freedom is the extent to which the civil law helps or hinders use of that right. I'll touch on this, but my main aim is to connect our thinking about what churches say about religious liberty in their teaching and in their church law. And I'll offer at the end of each little section a little question. My premise is that church laws represent an important expression of Christian thinking about and commitment to religious freedom as these are translated into action through norms of conduct in the church. I'll explore 5 propositions in light of churches in the UK and the Commonwealth, because quite frankly, the churches in the UK, their treatment of this subject is not all that brilliant. So I've got to extend it. First of all then, the church's understanding of religious freedom. 3 points. 1, church's ideas on the nature of religious liberty mirror those in secular international law. 2, the church's reasons for religious freedom, of course, differ from those in international law. 3, the church's understandings are found or elaborated in church teaching, not usually in church law. For Christians, freedom is essential for faith. We know that. The World Council of Churches puts it this way: God's redemptive dealing with humankind is not coercive. Therefore, attempts by a legal enactment or by pressure of social custom to coerce or eliminate faith are violations of the fundamental ways of God with men. The freedom which God has given implies free response to God's love. That's a global World Council of Churches position. Let's look at the individual traditions. On the one hand, at international level, some churches have a rich concept of religious freedom. The Roman Catholic Church, of course, is an obvious example. The Vatican II Declaration on Religious Freedom, 1965 Dignitatis Humanae, places religious freedom within its traditional teaching about human dignity. Religious freedom is the cornerstone of a society that promotes human dignity. It is a fundamental human right. It follows on the duty and right of all people to seek religious truth. It includes freedom from and for religion. This is all in Dignitatis Humanae. It requires society both to refrain from preventing people from living their religion and to help create conditions for religion to flourish. A free society is one in which people actively seek religious truth and fully live it out in public and private. Also, as humans are social beings, it belongs to groups, not just to individuals. So, religious communities may govern themselves, worship publicly, appoint ministers, witness to the faith, admit members, instruct members, and so on. But Dignitatis Humanae, of course, recognizes the limits on the exercise of freedom, of religious freedom. It is exercisable, I quote, provided the just demands of public order are observed and subject to certain regulatory norms. These include respect for others' rights, duties to others, and the common good, the right of society to defend itself against abuses committed on the pretext of religious freedom, the adequate care of genuine public peace, and the proper guardianship of public morality. Therefore, the Council concludes, religious freedom should be everywhere, provided with an effective constitutional guarantee. On the other hand, some world religions have rather less sophisticated ideas about the nature of religious freedom. For example, in the Anglican Communion, the Lambeth Conference simply endorses wholesale the idea of religious liberty set out in the UDHR, which perhaps crudely it sees and understands explicitly as an absolute right in its entirety. The principles of canon law of the Anglican Communion, 2008, these are principles induced from the laws of the 43 member churches. They are not laws in themselves, but principles of law. These principles of canon law in the Anglican Communion recognize within a church that all persons have inherent rights inseparable from their dignity as humans created in the image of God. But there's absolutely nothing in these principles on religious freedom in civil society. Lutheran ideas also mirror international law. The Council of the Lutheran World Federation in 2013 issued a statement on religious freedom. This too affirmed the UN approach. But importantly, it also explained that the Federation believes that religious liberty is a right given by God to all. It's a belief. The General Council of the World Baptist Alliance in 2017 also saw religious liberty as a gift of God to all people and committed itself once more to the understanding in the UN Declaration. At national level, while churches sometimes define human rights, they only occasionally define religious liberty. For instance, the United Methodist Church law acknowledges all persons are equally valuable in the sight of God, having inherent dignity, and religious liberty involves, this is not a definition, just the indicia, it involves freedom from legal, economic, and social discrimination. Link with discrimination. 2, for the United Reformed Church in Great Britain, I quote, civil authorities ought to respect the rights of conscience and religious belief in order to serve God's will of justice and peace for all humankind, an idea of purpose there. And the Baptist Union of Southern Africa into the Commonwealth, their bylaws accept the principle of religious liberty, of course, one of the fundamental Baptist principles, the principle of religious liberty, i.e. that no individual should be coerced either by the state or by any secular, ecclesiastical, or religious group in matters of faith. As such, in each sphere, the right of private conscience is to be respected. So, if this sketch, and it is just that, is accurate, the Church's official understandings of religious freedom in their law are far less well developed than those of scholars from these ecclesial traditions, whose concepts we know about the nature of religious liberty do not simply mirror international law, but develop ideas beyond international law, beyond the bare notion that religious liberty is the will of God, this theocratic element, so to speak, of religiously. So, why are official church teaching and law so rudimentary in their understanding of the content of religious liberty? Why so basic? Why, provocatively, do they slavishly follow that understanding in international law? Secondly, the churches as advocates of religious freedom in civil society. Again, 3 points. John, there's always 3 points. 1, Churches are advocates of religious liberty in civil society. 2, international church communities assert for themselves either a corporate right or a corporate duty to advocate it, or they exhort advocacy by member churches, and they do so in their legal instruments. 3, they have bodies to promote human rights in general, and sometimes commissions and so on to promote religious freedom in particular. And these arrangements, these ideas, principles are mirrored at national level. Roman Catholic law asserts the church's right to advocacy, not duty, right. The church has the right to proclaim moral principles, even in respect of the social order, and make judgments about any human matter if this is required by fundamental human rights or the salvation of souls, etc., etc. But there is no canonical duty on the church in the 83 Code to advocate human rights. An Anglican Lambeth Conference resolution of 1998 speaks of a responsibility for religious liberty. It calls all faith, the objects of this responsibility are extraordinary. This is the Lambeth Conference. It calls all faith communities, especially the church, to acknowledge our responsibility to mobilize our spiritual, moral, and material resources to promote religious liberty. It also exhorts governments to strive for the creation of just and free conditions for all religions to practice their beliefs. But the conference resolutions are not laws. We know that. They are not laws. They do not bind the autonomous member churches. So the resolution of 1998 is merely an exhortatory norm. And I find no law in any Anglican church obliging a church to promote religious liberty in civil society. It's just not there. But churches, of course, actively engage in religious freedom advocacy in the communion, that is, through church commissions. Some of them are mandated by law, some of them are permissive, but generally they're about the promotion of human rights in total, not specifically religious freedom. Protestants are different. The Lutheran World Federation Constitution places a duty on the Federation to promote peace and human rights. Its Council Statement on Religious Freedom 2013 calls on member churches and the ecumenical community to strengthen their commitment to religious freedom, to cooperate in promoting it in their own societies, and for its churches to intercede with both state and religious authorities for its defense. The World Communion of Reformed Churches has also a constitutional duty to engage in promoting and defending religious, civil, and all other human rights wherever threatened in the world. And one constitutional object of the World Baptist Alliance is to defend human rights globally, I quote, including full religious liberty. And it has a commission on religious liberty. And the Alliance, the Baptist Alliance, on the basis of this legal duty, as we know, is very active in the promotion of religious liberty advocacy. Now, similar advocacy duties appear in laws at national level. One little example, the law of the United Methodist Church requires that church to defend religious freedom, combat hatred based on religious affiliation, support policies that ensure the right of every religious group to exercise its faith free from legal and political restrictions, and to condemn all forms of religious intolerance and discrimination. That is a legal duty placed on that church by itself, an assumed legal duty. Now, an ecumenical panel of experts was formed in Rome in 2013, Christian leaders, lawyers, theologians from 8 different historic churches worldwide. And in 2016, the panel issued a statement of principles of Christian law. Here they are. A statement of principles of Christian law, induced, that is, from the similarities existing between the legal systems of the 8 churches, Catholic, Anglican, Orthodox, Lutheran, Presbyterian, Reformed, Baptist, and so on. Now, the principles say all humans have been created in the image of God, share in equality of dignity and fundamental human rights, and the church should protect and defend human rights in society for all. But the text did not deal with religious liberty in society as such. It could have, as we'll see, I hope, at the end of this little talk, but it did not. So, the primary duty to protect religious liberty is on the state, but churches assume for themselves either a right or a duty to promote it, Episcopal churches use a right, and Protestant churches tend to use a duty. In some churches, the duty is imposed by teaching, in others by law or by soft law, and in some by both. So, should the church law and its laws, should churches and their laws require churches to engage in religious liberty advocacy? What difference would that make, if any? And whether it is a right of advocacy or a duty also affects, of course, society's expectations about church advocacy on religious liberty. 3, the church uses religious freedom as an ecumenical instrument. Churches use religious freedom as an ecumenical instrument. The ecumenical movement seeks greater unity between churches. The laws of most churches contain a duty to engage in ecumenism on the basis of their membership, asserted membership of the Church Universal. But does the movement and churches party to it require ecumenical collaboration to promote religious liberty in society? The World Council of Churches has a number of documents on religious freedom, and they show how religious freedom can serve as this instrument of ecumenical endeavor. 3 of them. First of all, a Declaration on Religious Liberty, 1948, adopted, in fact, at the inaugural conference in Amsterdam in 1948, before adoption of the UDHR. First of all, religious liberty is both a Christian and an international matter. Oh, dear me. I'm sorry about that. There's the movements of hands. Any experts here? How do I do that? I'll leave it on. Oh, well, it's half on, half off. Sorry, I've never really been very good at it. Is that working? I've never been very good at these technical things. Okay. First of all, religious liberty is a Christian and an international matter. Now, a little lengthy quote here from this Declaration on Religious Liberty. An essential element in international order is freedom of religion. This is an implication of the Christian faith and worldwide nature of Christianity. Christians thus view religious freedom as an international problem. They are concerned that it be everywhere secured, but do not ask for any privilege. While the liberty by which Christ has set men free can neither be given nor destroyed by any government, Christians are jealous of its outward expression and solicitous that all should have freedom in religious life. The nature and destiny of man from his creation, redemption, and calling establish limits beyond which governments cannot go. This again is the theocratic element. Rights Christian discipleship demands are good for all. No nation suffers in granting them, says the Declaration. Secondly, the rights in the Declaration shall be observed for all persons without distinction as to race and so on. Thirdly, the Declaration sets out 4 rights which embellish international law. We know about these. But this is the World Council of Churches declaration. First of all, everyone has the right to determine his own faith and creed, including the process to adhere to or change belief, instruction, access to information to allow personal decisions as to belief. But there are limits. All ought to take into account their higher self-interests and belief implications for others' welfare. Secondly, everyone has the right to express his religious belief in worship, teaching, and practice, and proclaim the implications of his beliefs for relationships in a social or political community. This includes, amongst a whole list of them, preaching and persuasion. This is 1948, World Council of Churches, 1948. The right to persuade. But the right's use may, of course, be limited to protect order, welfare, morals, and others' rights. Third, everyone has a right to associate with others and to organize with them for religious purposes, but under limits set for all associations by non-discriminatory laws. Fourthly, every religious organization formed or maintained by action in accordance with the rights of individual persons, coming from the individual right, has the right to determine its policies and practices for the accomplishment of its chosen purposes. And this right includes rights, for example, to determine its faith and govern itself. And the state must respect religious autonomy. But a religious organization must respect the rights of other organizations and safeguard corporate and individual rights in wider society. The next document is On Religious Liberty, 1961. Hands up, how many of you have heard of this document? The World Council of Churches document on religious liberty. Not too many, in fact, 2. It's a fascinating document. First, and it adds to and in a sense embellishes the 1948 WCC declaration. 1, there is a need to reinvigorate efforts to ensure everyone has religious freedom. These are bare, simple things, I know, but just get them on the table, as it were. 2, religious liberty is a distinctive human right based on the inherent dignity and inalienable rights of all in the human family. 3, the freedom with which Christ has set us free calls for responsibility for the rights of others. The civil freedom we claim in the name of Christ must be freely available for all to exercise responsibly. Now, responsibility. 4, it is the corresponding obligation of governments and society to ensure the exercise of these rights without discrimination. And 5, churches in their own witness and life should recognize their own past failures in this regard to promote religious freedom in wider society or to promote it within themselves. They should recognize their past failures in this regard and play their indispensable role in promoting religious freedom. The 1961 instrument does not require churches to cooperate ecumenically in religious freedom advocacy. Finally, we've got the World Council of Churches International Affairs Commission, which in 2003 discussed religious freedom in the emerging context. And it widens this duty to protect religious freedom as a shared obligation between church and state, between churches themselves, between individual Christians and the churches, and between Christians and people of other faiths. So this responsibility, this duty to protect religious freedom in wider society is now a shared duty of all people, of all Christians, working with each other and so on. The Commission also recognizes the need to review the definition of religious freedom in light of the experience of churches. Why? Well, it doesn't say it's because of the impoverishment, the poverty of the church's own definitions of religious freedom, because they slavishly follow that in international law. Okay, there's a question of how influential are the churches in creating that definition of religious freedom. But it's not because of that. It's because, 1, religion has emerged as a key factor in national, civic, and political life. 2, religion is now seen variously as theology, ethics, and culture, so we must revise the definition of religious freedom. 3, state religion with constitutional powers and privileges may jeopardize the freedom of citizens to choose and practice the belief of their choice. Next, the secular and plural basis of the state is under assault, and religious extremism and intolerance is on the rise. And lastly, difficult questions arise for the ecumenical movement and its own position, its own opposition, fairly recent, to proselytism. Now, the Faith and Order Commission of the World Council in Churches in 2013 basically agreed with all these things, and it also said there's a need to enhance, develop, increase greater religious liberty literacy in international diplomacy. So, whilst laws of most churches contain a duty to engage in ecumenism, and while they may have a duty to promote religious liberty, I have found no church imposing a legal duty on itself to collaborate ecumenically in the advancement of religious liberty. Such duties just do not exist. The WCC assumes for itself a duty to promote it, but the duty it identifies for churches to collaborate with each other in this is merely an aspirational norm. It's not legal. The Council, of course, has no competence to compel or oblige autonomous member churches to change their legal systems in that direction. So, should churches impose on themselves a legal duty to collaborate ecumenically in the religious liberty enterprise? 4, the churches must safeguard their own religious freedom. This is the 4th point. We're doing very well. Well, I'm doing very well. No. There's something so unreal about this, isn't it? Dear me, I never cease to be amazed at these conferences. I mean, extraordinary things. How you can sit there and listen to this, I do not know. But anyway, I've got 10 minutes. I'm just going to have a little look at my... oh, yes. I'm worried about Mark, you see, because he gives me hell if I don't keep to the time. To my mind, Mark, generally, And I agree with you here, Mark. The religious freedom of churches in the UK civil law is not under threat, in part because the churches agree with the civil regime. As we've seen, churches' understandings of the right is consonant with that of international law and therefore domestic state law. But the reasons for it differ, of course. For churches, the reasons are spiritual. For the state, the reasons for religious freedom are temporal. Whether the civil regime in which the churches participate should be reformed, that's, of course, a different question. And churches may and do, of course, litigate the application of this regime with which they agree to particular cases if the government interferes with their exercise of the civil right. Needless to say, churches are therefore beneficiaries of the civil right. And they, importantly, assert their own religious freedom in their own law. They assert their own religious freedom in law. They don't have a legal duty to collaborate ecumenically with other churches to protect it in civil society. But my goodness, don't they half assert their own religious freedom in their legal systems? First of all, from the perspective of the state, we know all this stuff, so I'm not going to bother. The incorporation of Article 9 into UK law, we know how the churches are beneficiaries. They can freely negotiate statutes with the state to protect their structures and property. They're free to set up charities, subject always to the limitations of public benefit and all the other things being recognized by the Charity Commission. They can operate internal systems of law, and the rules of these laws are enforceable in the state if the churches ignore them, if there's a property or a civil right involved, and these rules are seen as terms of a contract, and churches are free to do that. I'm ending up doing this, so I might as well turn back. And so on. We know about the state perspective of the balance between ecclesial freedom under civil law and its exercise, and the possibility of state law limits on its use. Second, more importantly, from the perspective of the churches, the principles of Christian law, this document, which, as I say, is being fed into the work of the World Council of Churches, provide that a church is autonomous in its system of government. The laws of all churches say, we are free. Thus, for example, a church has the right to acquire, administer, and dispose of property. The legal systems assert that. However, the principles also state a church should cooperate with the state in matters of common concern. But each church is independent in its own sphere, and cooperation between church and state may be exercised on the basis, for example, of establishment, an agreement between the state and the church, a piece of legislation freely negotiated between a church and the state, the common approach in the UK, or juridical personality in civil law. Crucially, I quote, a church has institutional autonomy to carry out its lawful objectives and freedom in these areas from intervention by the state. This is a principle of Christian law of the historic churches, induced from explicit statements to this effect in the laws of churches. The key point, whilst separate institutionally or functionally, church and state are somehow related. So the freedom of churches and their understanding of it and exercise of their own asserted religious freedom is subject to that relationship, in which churches acquiesce freely. Let's take 3 examples across the ecclesial spectrum. For the Roman Catholic Church, there's no authority except from God. The political community is based on human nature and so belongs to an order set up by God. Political authority must be used within the limits of the moral order, and the state must defend the common good. Yet, in their own domain, the state and church are independent, but should develop mutual cooperation for the good of all. The church, in its law, claims for itself a right to carry out its mission, but Canon 22 of the 83 Code says, when the law of the church remits some issue to civil law, the latter is to be observed with the same effects in canon law. It is not if it is not contrary to divine law, and if it is not otherwise stipulated in canon law. Yet, bottom line, unjust laws would not be binding in conscience. That is, unjust laws of the state do not bind in conscience. The Lutheran Two Kingdoms is not dissimilar in its structure. A Commonwealth example, the Lutheran Church of Australia. God rules all people in his earthly kingdom through the agency of secular government, and he rules all Christians in his spiritual kingdom through gospel and grace. Christians are citizens of both, mutually dependent. Mutually dependent. The church needs the state for its liberty, and the state needs the church as the conscience of society to hold governments accountable to the public and ultimately to God. Church and state are distinguished but not separated. Each has its own sphere of competence and responsibility. The state must not interfere with proclaiming the gospel, and the church must not use the state to promote the gospel, Christianize society, or interfere in state affairs. Do you see how rich these legal instruments are in terms of ideas about this thing? But the church must witness to the truth and condemn state acts and laws even if persecution ensues. The faithful must obey civil law, but, quotation, obedience to it is never absolute but always limited. If it means disobedience to God, allegiance to God comes first. Same idea operates in a great many other legal instruments at national level. Let's just leave those there. The point. Generally, religious church freedom, ecclesial freedom, here in the UK is not under threat, I don't think. Churches agree with and participate in the civil regime. In their official teaching and legal instruments, that is. They assert their own freedom, their institutional separation from the state, and their duty to obey its law unless the faith itself is threatened. So could these be candidates to include in this statement of principles of Christian law? Finally, 5, the church regulates and limits its own religious freedom. The church was born free but with duties fixed by divine law to proclaim the faith, worship and care for people. To what extent then do churches permit internal religious freedom, which they advocate in civil society? The pattern emerging is that churches legally reverse the image of religious freedom in civil law. Civil law begins with the right and moves to limits on its exercise. Church law begins with duties on the faithful and moves to freedoms found in exceptions, in discretions, in structures for relaxation of law. Now, fundamentally, the terms of religious freedom within a church, oops-a-daisy, and the extent it is enjoyed by the faithful are defined by law, defined by church law, and they are summarized in the principles of Christian law, which seek really, on the legal evidence upon which they are based, to balance this business of ecclesial freedom and limits on its exercise. It's the nature of church law, as it is with any law. 3 or 4 little points. Church law is a servant. It exists to serve a church in its mission and witness to Christ. Laws constitute the institutional organization of a church and facilitate and order its activities. Theology shapes law, and law realizes theological propositions in norms of conduct. And church laws should conform to the will of God, so say the principles, as revealed in Scripture and by the Holy Spirit. 2, as to the scope, structure, and effect of law, laws deal with ministry, government, the whole gamut of ecclesial life. Ministry, government, liturgy, property, doctrine, relations with the state, ecumenism, and so on. And importantly, they consist of, like any other legal system, precepts and prohibitions and permissions. They bind. All church members are subject to its laws. A church may enforce and vindicate rights and duties of the faithful. This is freedom, but its exercise may be limited. Then we have the rule of law. A church institution is not free to act as it wishes, but it must comply with the law. And it must satisfy substantive limitations on the exercise of its powers and procedural limitations too. And as to the faithful, of course, church laws just spell out in enormous detail the rights of all the faithful, lay people, and if the church has ordained ministers, ordained as well. But the position is, you read these legal texts, and they pretty much always begin with the obligations of church membership, the duties of church members. Then they move on to rights and privilege. The focus is duty. However, church laws also provide for freedom through mechanisms like the notion of dispensation in Catholic canon law, the principle of economy in Orthodox canon law, the principle of officium, nobile officium in Presbyterian law, and so on. Conclusion. I think there is a strong case for provision on religious freedom to be included in the Statement of Principles of Christian Law, currently being developed by this panel of experts with the Faith and Order Commission of the World Council of Churches. The following are offered as candidate principles of law. 1. The free pursuit of religious truth is a universal value. These are principles of law. The free pursuit of religious truth is a universal value, a necessary element of the Christian faith, and a gift of God, and the state should respect and facilitate that. Why? 2. Churches should be advocates of religious liberty for all in society. Each church should have institutions dedicated to its promotion in the public sphere. 3. Churches should cooperate to promote religious freedom in civil society, globally and locally, as part of the ecumenical enterprise for church unity. It should be an ecumenical duty. 4. A church should act as a guardian of and protect its own religious freedom in civil society and civil law, so as to carry out its mission and its witness. 5. A church should, in its laws, clearly define the rights and duties and freedoms of its faithful and the limits on and relief from the conscientious exercise of both. There we are. I'm a minute over time. I do apologize. Thank you.
Well, if I read our program correctly, I am the last scheduled panel speaker. And while I know that our friends at the McDonald Center and the Emory Center for Law and Religion have been thanked often, they can't be thanked often enough, so I will thank them again. And in particular, I'm very grateful to Ginny Dunn and Amy Wheeler for making this possible. Believe me, please, that it is not false modesty when I say I feel a bit like I've tricked my way into the speakers lineup here. I can't get away with pretending to be a young law professor anymore, but ever since I was a young law professor, my friend John Whitty has been a generous and valued teacher and mentor and role model, and so I'm very grateful to be with him again and grateful to him for including me. While I'm clearing my throat, I want to say it's a real treat to be back here at Oxford. 30 years ago, I spent a year here as a student that was one of the most enriching and rewarding of my life. Although, well, that's what I tell my children. Truth be told, I spent most of my time rowing boats on the Isis and drinking pints in the Bear, but it was rewarding nonetheless. And then finally, by way of introduction, I feel that, and I'm a Roman Catholic, so this won't surprise you, I feel the need to confess. Yesterday's robust and energetic defenses of the Church of England and the Elizabethan settlement make me feel like I need to tell you that I am the distant and not direct, but nonetheless the relative of Father Henry Garnet, S.J., who was executed for his alleged role in the gunpowder plot. Sorry about that. No harm done. So our topic is religious freedom in the 21st century, and I'm a little out of my depth on this one. My friends and my critics tend to think that I'm too hung up on the 4th and 5th centuries, or perhaps in my modernist moments, the 11th and 12th, as being the keys to the story of religious freedom. I'm one of those weird Americans that thinks that Galatius and Becket are more interesting than Madison and Jefferson. But since the invitation comes from my friend John, I'll drag myself reluctantly into the present. So I want to start with some abstract thoughts and persist in some abstract thoughts and then conclude with a few specifics. To pick up on Mark Hill's art gallery metaphor from yesterday, I'll start in the room with the Klees and the Kandinskys, and then eventually I'll probably end up with some Van Eycks. My proposal in a nutshell is that thriving, independent, and free religious institutions are crucial and necessary for religious and political freedom under law. In other words, what I and many others call, quote, the freedom of the church is an essential dimension of religious freedom. And the question for us is whether that freedom is vulnerable or, quote, under threat. I want to start with two quotations taken from opinions written by two justices of the United States Supreme Court. The first is from Justice William Douglas, dissenting in the 1972 case of Wisconsin versus Yoder. Douglas was objecting to the court's ruling that Amish families were constitutionally entitled to an exemption from a state law requiring children to attend school after grade 8. He thought the court was overvaluing tradition and community, and he insisted, and here's the first quote, "Religion is an individual experience." Well, certainly it is, but the question for us this morning, I think, is it only that? Justice William Brennan, writing in a 1987 case called Corporation of the Presiding Bishop versus Amos, said, "No, not everyone sees it this way. For many people," he wrote, "religion is a group activity. People form communities of faith. They worship God together. They agree on creeds. They instruct and correct each other. They recruit new members, and so on. This is not just a matter of sociability. It is often built into the structure of religious beliefs. Jewish law requires the presence of 10 men for the conduct of prayer services. Roman Catholic canon law provides that unless there's a good reason, a priest must not celebrate Mass without the participation of at least one of the faithful. So, as Justice Brennan put it, quote, "Religion includes important communal elements for most believers. They exercise their religion through religious organizations, and these organizations must be protected by the Free Exercise Clause. For many individuals," he continued, "religious activity derives meaning in large measure from participation in a larger religious community. Such a community represents an ongoing tradition of shared beliefs, an organic entity not reducible to a mere aggregation of individuals." Now, of course, we may, and in America we often do, think of religious groups as associations of individual. Part of the individual experience Justice Douglas spoke of may be the freedom of religious association, that is, voluntarily joining with like-minded believers. And this approach, this way of thinking, fits well with some Protestant forms of ecclesiology. But others maintain that the religious congregation is not just an association of individuals. It is instead an irreducible whole, the basic unit of religious life. So here's the first step in what I hope will be a full argument. The right to freedom of religion belongs not only to individuals, but also to institutions, associations, communities, and congregations. Just as every person has the right to seek religious truth and to cling to it when it is found, religious communities have the right to hold and teach their own doctrines. Just as every person ought to be free from official coercion when it comes to religious practices or professions, religious institutions are entitled to govern themselves and to exercise appropriate authority free from official interference. Just as every person has the right to select the religious teachings he will embrace, churches have the right to select the ministers they will ordain. These organic entities are subjects, not just the results or the byproducts of religious liberty. At the center of religious freedom, then, is what is called in American constitutional law, quote, church autonomy. But religious freedom and autonomy are not just things that churches have, and they are more than things that are simply possessed. And so here's the second point. The right to church autonomy, as I see it, should also be seen as a means, a structural mechanism for protecting both the freedom of religion and human rights more generally. The relationship between the enterprise of protecting human rights and religious communities' right to self-determination is a dynamic and mutually reinforcing one. Human rights law, in other words, and constitutional law more specifically, protects church autonomy. It protects the freedom of religious communities to govern them and organize themselves, to decide religious matters without government interference, and so on. It does this, and in turn, church autonomy promotes the enjoyment and exercise of human rights by others. Now, admittedly, Americans' way of thinking about rights is, generally speaking, individualistic. Rights, we think, tend to attach to particular people and to protect them, their privacy, their interests, and their autonomy from outside authorities. And so it should come as no surprise that American judicial decisions and American public conversations about religious freedom tend to focus on matters of individuals' rights and beliefs and consciences and practices. Again, the Justice Douglas quote. However, as Marianne Glendon demonstrated almost 30 years ago in her compelling critique of American rights-based political discourse and of the legal regime that discourse produces, this individualistic focus of ours can be myopic and distorting. It can cause us to overlook and neglect the social context in which persons are situated and formed. And it can cause us to overlook and neglect the distinctive nature and role and freedoms of groups, associations, and institutions. Now, to be sure, the individual human person, every single one, matters. He is, in the words of my former teacher, Tom Schaefer, quote, infinitely valuable, relentlessly unique, and endlessly interesting. Every person carries, in C.S. Lewis's words, the weight of glory. There are no ordinary people, Lewis once insisted. You have never talked to a mere mortal. Nations, cultures, arts, civilizations, these are mortal, and their life is to ours as the life of a gnat. It is immortals whom we joke with, work with, marry, snub, and exploit. Immortal horrors or everlasting splendors. I feel like we should just go to the Eagle and Child now. I read from C.S. It is fitting, then, that the image of the lone religious dissenter heroically confronting overbearing officials or heroically confronting extravagant assertions of state power, it makes sense that this image is at the center of our thinking on religious freedom. It's evocative and timeless to picture the lone dissenter armed only with claims of conscience. I might think of St. Thomas More as he is depicted in A Man for All Seasons. Here in Oxford, we might think of Latimer, Ridley, and Cranmer instead. But in any event, no account of religious freedom would be complete if it neglected such clashes or failed to celebrate such courage. Still, Professor Glendon is right, I believe. Something goes missing when the freedom of religion is reduced to the individual's liberty of conscience, to her freedom of belief, or even to her right to engage in worship or religiously motivated action. A legal regime of human rights that is designed to protect only this reduced notion of human freedom will leave vulnerable some important aspects of that freedom, including perhaps its corporate and institutional dimension. Such a legal regime might misfire because it describes and categorizes the world in an incomplete and perhaps even a distorted way, passing over and leaving out some things that matter. We should want our constitutional law to capture faithfully what is significant and what really matters about the real world that our constitutional law governs. We should want our human rights law to see and so to respect and protect the freedom that rightfully belongs to religious groups, that is, to churches. And, despite its individualistic orientation, I believe that American constitutional law does this. That is, the American Constitution guarantees religious freedom not only to believers, but also, quote, to the church as an organized society within its own law and jurisdiction. What the United States Supreme Court has called ecclesiastical rights, no less than individuals' rights, are protected by the First Amendment. And again, these rights are not merely derivative of or proxies for individuals' rights. These rights are not simply vehicles for securing individuals' liberties. Now, as we've heard already, the American Constitution's protections for ecclesiastical rights are not idiosyncratic or anomalous. The fact that religious freedom has a communal and a corporate aspect and that it includes a right to autonomy is acknowledged in many other nations' domestic laws and in international human rights decisions and instruments. So it seems clear, I think, that the freedom of religion, which the Constitution protects, is enjoyed by institutions as well as individuals. What's the content of this protection? What exactly is church autonomy? What does it mean on the ground and in practical terms? Well, in the United States, anyway, the church autonomy principle is implicated in a wide variety of disputes and contexts, and I'll name just a few. the supervision of diocesan finances by a bankruptcy court or an administrative agency, a requirement that religiously affiliated organizations pay for employees' contraception, or that doctors in religiously affiliated hospitals perform abortions, in litigation regarding church discipline proceedings or membership requirements, in the division of church property after a schism or split, in the application of non-discrimination laws to churches and religious schools' decisions about the hiring and firing of clergy and teachers, and in efforts by government to control or to regulate churches' selection of their leaders, to mention just a few. The church autonomy principle is probably not reducible, much to the regret of my law students, to any single test. In many ways, the church autonomy doctrine is less a rule than a grab bag of holdings or a collection of themes. But this collection of themes is animated, I believe, by what the Supreme Court has called the spirit of freedom for religious institutions. We know that the First Amendment does not permit state action that creates, quote, excessive entanglement between the government and religious institutions or teachings. We know that the Constitution commands that, quote, secular and religious authorities must not interfere with each other's respective spheres of choice and influence. We know that the justices have refused to, quote, undertake to resolve religious controversies because the hazards are ever present of inhibiting the free development of religious doctrine. The court has affirmed time and again the, quote, fundamental right of churches to decide for themselves, free from state interference, matters of church government, as well as those of faith and doctrine, and so on. Well, so far I've tried to make the case that the freedom of religion has a communal, corporate, public dimension as well as a private one. It is enjoyed by, and it safeguards the rights of, individuals as well as, institutions as well as individuals. Is this freedom vulnerable? Is it under threat? I'll say more about this question in a bit, but for now, let me just say it matters if it is. It matters because there are crucial connections between pluralism and constitutionalism. There are crucial connections between the autonomy of religious institutions and the rights of individuals. The American Jesuit John Courtney Murray explored and emphasized these connections with care. In his view, we are not really free. None of us, whether religious believer or not, is really free if, quote, our basic human things are not sacredly immune from profanation by the power of the state. The challenge is and has long been to find a limiting principle that can check the encroachments of civil power and preserve these immunities. And he thought that Western civilization first found this norm in the principle of the freedom of the church. This principle, Murray thought, is served as the, quote, new Christian theorem, namely that the church stood between the body politic and the public power, not only limiting the reach of the power over the people, but also mobilizing the moral consensus of the people and bringing it to bear on the power. For Murray, it was the freedom of the church, the autonomy of the church, that furnished a, quote, social armature to the sacred order, within which the human person could be secure in all the freedoms that his sacredness demands. He believed that, quote, the protection of aspects of life from the inherently expansive power of the state depended historically on the freedom of the church, and now I think we would say the churches, as an independent spiritual authority and as a rebuke to Hobbesian or Jacobin pretensions by the political power. Here's another way to put it. In recent years, Professor Jack Balkin and others have emphasized and explored what they call the, quote, infrastructure of free expression. And they've noted that the freedom of expression requires, quote, more than the mere absence of government censorship or prohibition to thrive. It also requires institutions and practices and technological structures that foster and promote the freedom of expression. That is, the freedom of expression is not only enjoyed by and through, it also depends on the existence and flourishing of certain institutions. And he lists newspapers, political parties, interest groups, libraries, and so on. These First Amendment institutions are infrastructural. They play a role in clearing out and protecting a civil society space within which the freedom of expression can be exercised. These institutions create the conditions and the opportunities for the exercise of that freedom. And in my own academic writing, I've suggested that similar infrastructural claims can be made with respect to the freedom of religion. Like the freedom of speech, religious freedom has and requires an infrastructure. And the freedom of the church, or the churches, is a way of thinking and talking about that infrastructure. Like free expression, religious freedom is not exercised only by individuals. Like free expression, its exercise requires more than an individual with something to say. Like free expression, it involves more than protecting the solitary conscience. The freedom of religion is not only lived and experienced through institutions, it is also protected and nourished and facilitated by them. And so, if we want to understand well the content of our constitutional commitment to religious liberty, we need to ask, as my friends Professor Lupu and Tuttle have put it, whether, quote, religious entities occupy a distinctive place in our constitutional order. And I believe that they do. We should acknowledge and take care of this distinctive place, and we should attend carefully to the health of religious freedom's institutional infrastructure. This means that we need to think, and perhaps also to worry, about both the freedom and the vitality of the churches. So, is religious freedom, as I've presented it, under threat? Here's a piece of evidence that it isn't, at least in the United States. In a striking and unanimous, and therefore striking because unanimous, 2012 decision, the U.S. Supreme Court affirmed that anti-discrimination laws cannot be used to second-guess religious institutions' decisions about ministerial employees. Period. Cannot be used. Now, I admit, and those of you who are American scholars will probably agree with this, part of the reason for the court's unanimity is probably because of incompetent lawyering on the government's part. But still, we'll take it. It was unanimous. All of the justices agreed that, quote, both religion clauses bar the government from interfering with the decision of a religious group to fire one of its ministers. All of the justices traced this ban to the time of Becket and Henry II and before. All of the justices rooted this rule in consistent U.S. practice and Supreme Court precedent. All of the justices agreed that, quote, interfering with the internal governance of a church violates the Free Exercise Clause, quote, which protects a religious group's right to shape its own faith and mission, and the Establishment Clause, quote, which protects which prohibits government involvement in ecclesiastical decisions. And they all agreed that the First Amendment gives, quote, special solicitude to the rights of religious organizations. It's true there are a number of questions that were left to be worked out in this opinion. Who counts as a minister, for example? But still, unanimous. As my friends on this side of the Atlantic would say, well done. And yet, there are reasons to worry, I think, about the role and the vitality of churches, and about the state of America's religious freedom, in quotes, infrastructure. And so here we leave the abstract part of the gallery with the blotches and lines, and we get to the room that's full of this, the still lifes of bowl of fruit and so on. I'll mention 4 of these causes for concern. So first, quite simply, is bad behavior or worse by religious institutions and church leaders. The most glaring example, of course, is the response of some Catholic bishops to sexual abuse by clergy, but there are many others. Arrogance and negligence and incompetence produce, no surprise, both a lack of confidence in churches and the loss of churches' authority. And these, in turn, undermine the church's ability to play their, quote, infrastructural role. Next on the list of causes for concern is the general deinstitutionalization in American life and culture. This has been studied and explained probably most famously by Harvard's Robert Putnam, including in his book, Bowling Alone. But we see that online clusters of individuals sorted by their grievances or their identities are replacing civil society institutions, including churches. Fewer children might mean that parents have more free time, but fewer children also means that there are fewer occasions to volunteer for school trips, for sports coaching, and for Sunday school teaching. Charles Murray has suggested that in many respects America is separating and, quote, coming apart, and it is not clear that our churches can or will hold us together. Third, and related, there's the so-called rise of the nones, N-O-N-E-S. That is, those who claim no religious affiliation. Now, Professor Glendon reminded us on Wednesday night, these people are not necessarily unreligious, but they are un- or de-churched. They are unengaged, not volunteering, and not financially supporting the church's corporate, institutional, and structural roles. And of course, the churches are not meaningfully competing with the state for loyalty or for authority in these unaffiliated persons' lives. And finally, and related to all three of the others, is the trend toward regarding religious freedom as the luxury good of a few, as a concession to be extended, perhaps, to the few, rather than as a common good in which we all have a stake, like clean air and clean water. These days, in American news stories, religious freedom gets the scare quotes treatment, rather than being seen as a vehicle for human flourishing on behalf of all people. As Mary Ann Glendon suggested, one threat to religious freedom is the fact that many are coming to see it and the churches as the threat. The appeal of an idea that seems to privilege institutions over individuals can only wane as we continue to think more and more in terms of personal spirituality than institutional affiliation or tradition or public worship. And in fact, it is common and perhaps understandable to regard churches and their autonomy claims as dangerous centers and sources of oppressive power, and less as structural protections for private conscience in need of supervision and regulation by the state. So in conclusion, churches and other religious communities do enjoy, as they should, a broad freedom to organize, govern, and direct themselves and their affairs in accord with their own teaching. I've suggested that this freedom not only benefits from, it also contributes to the enterprise of human rights law and of constitutionalism more generally. But that said, there's no avoiding the fact that church autonomy principles and church autonomy premises are vulnerable and in some contexts under stress. The right clearly exists, but its scope and its foundation are increasingly contested. To the extent that we approach religious faith as a form of self-expression, as performance, as therapy, we are likely to regard religious institutions as, at best, potentially useful vehicles, or more likely as stifling constraints or bothersome obstacles to self-discovery. This, however, would be a mistake. Thanks.
Okay, well, thank you for some fascinating, energetic talks, particularly at 9 a.m. And we're going to have some questions. We've got to 10:30, so we've got some time for some questions.
Michelle, University of Oxford. Professor Doe, you said that.
Yes, I'm
You said that the Catholic and Anglican churches admit a right but not a duty to promote human rights. And I was wondering what you thought the rationale behind and the implications of this decision or position are.
Right, so Catholic Church and Anglican churches tend to... Oh, thank you, yes. Is it on? Is it on? They tend to... Yeah, we're talking about the law. We're talking about their legal systems. And yes, you're absolutely right. I mean, it's very frequently when because there's a question about the sense. Why bother? Why should a church bother to impose duties upon itself to negotiate with a partner, the state, which may itself have a set of norms which refuses that partner to speak with the partner which has just imposed a duty on itself to speak to that partner. There has to be a mutuality of, of duties or rights. First point, I find it rather peculiar, actually, that churches place duties upon themselves to advocate religious liberty in civil society. I can see the theological reasons for it, but I think that structurally there are questions about what churches think they're doing when they do that, place a duty upon themselves, all right. Second point, what are the reasons for churches opting to either assert for themselves, act in accordance with a right to religious liberty advocacy in wider society, negotiating with the state and state actors and so on, and why do they have a duty placed upon themselves, and we must negotiate with the state about religious freedom because it's God and it's theocratic and it's the will of God that we do this thing. They may understand that there's a kind of divine law basis for that duty. But why they do that, I haven't got a clue. I think you have to ask them. And I understand that's called empirical research. I'm honest, but I could go on, and I invariably do. I've just done a book called The Legal Architecture of English Cathedrals, okay? And you have the Church of England's magnificent national law on cathedrals. The Cathedrals Measure, 1969, which has the authority of an Act of Parliament, one of the incidents of establishment, and various other pieces of statute. And every cathedral, each one of these magnificent historical heritage landmarks in England, okay, has its own law, its own domestic law, its own statutes and constitution. And I spent a wonderful summer in 2016 going around these cathedrals, interviewing their deans, the boss of the cathedral. And we sat there, Dean Rick, we had the statutes on the table, we had the constitution on the table, and there would be the wonderful preamble containing the theological foundations of the cathedral's own norms. And I'd say, Dean Rick, this wonderful theology, why have you got that stuff? Do you ever use it as a determinant in your governmental decision-making in the cathedral? Why have you got this rule? Do you ever use it? That rule, how much does it cost to run? This rule here, what does it mean? That rule, where does it come from? And so I was asking the lawmaker about the reasons for these bits of church law. And all these collectively contain a wisdom about the reasons underlying their own laws, a jurisprudence. So you've just unearthed a fantastic research project. To ask them, why do the legislators sometimes the reason's gone? If the reason's gone, why is the law still operative? If the reasons for the law have ceased, forget the law, ignore it, abandon it, break it. So you're not going to ask them.
I have nothing to add to that.
So we've got a question at the back, and microphone.
Hello, my question is for Professor Doe. You mentioned...
I mean, where is equality here?
I wouldn't mind an answer from both. You mentioned about a particular clause in the World Council of Churches Declaration, if I'm not mistaken, 1948, which talks about the right to pursue it.
Yeah.
My question is, A...
Sorry, the right to pursue what?
Right to pursue it.
To pursue religious freedom.
Persuade.
Oh, persuade, I thought, yeah, good, yeah.
My question is, A, would you interpret this as the right to propagate religion as a part of the exercise of religious freedom by the church as a legal person? And B, if hypothetically, under an anti-conversion law, and I ask this because anti-conversion laws are prevalent in many countries and are a burning topic there. So if hypothetically, under an anti-conversion law, a priest is prohibited to exercise this right to propagate religion by persuasion, would this be viewed as a violation of an individual right of religious freedom of that priest, or would it be a violation of a group right invested in the church as a legal person, which was merely exercised by the priest as a representative of the church?
Well, I mean, extremely brilliant, but difficult questions, obviously. The first one, the right to persuade, yeah, the text doesn't tell us what the intent was, as is often the case with legal or law-like texts. Unfortunately, they don't give us the reasons for the rules they contain. So you have to speculate about the intent of the norm maker, which is a deeply interesting, time-consuming, and very often speculative business. That's the trouble with legal text, isn't it? They don't tell us the assumptions on which they've based the decisions and the reasons to create the norm that appears in the text. So that's the case with that instrument, but I would assume, yes, it is both a collective and an individual right to persuade, whatever that means, because of course the text does not define persuasion. And in fact, you've got the later text from 2013, I think it was, in which they said the World Council of Churches has a declared position against proselytism. The World Council of Churches. So somewhere along the line, it changed its mind, if, that is, persuasion means proselytism. Third part of the question, if I were a judge, I would say yes to your last question. As an academic, I'd say, well, maybe not. And as a collaborative academic, I will ask Rick to answer that question.
Well, as I suspect everybody in this room knows, the United States has an extremely small L libertarian approach to the freedom of speech. And so I feel pretty confident in saying that in the American context, any effort on the government's part to limit in any way efforts to persuade in religious matters would be unconstitutional as a matter of the freedom of speech, putting aside questions of corporate free exercise rights or individual free exercise rights. And similarly, I think, knock wood, any governmental restriction on conversion would be kind of right out. As a matter of American constitutional law. Now, we are seeing in some contexts, and specifically in the context of workplace discrimination, there have been, and this is kind of, in my view, a problematic area, where in some cases, employers are cracking down on their employees' religious speech out of a concern that if they don't, they'll be held liable for permitting workplace religious harassment. And the line between, enthusiastic and exuberant evangelization on the one hand and harassment on the other is one that can blur in some contexts.
A question to both excellent speakers this morning, and you mainly addressed two actors throughout history, churches and states. And now, what we have seen, especially after 1948 and the Universal Declaration of Human Rights, you see a third actor or actors given the human rights revolution. All the human rights activists around the world that also present challenges in terms of human rights to the churches and to the states around the world. And in the preamble of the Universal Declaration, it is stressed the universality that it applies to all actors within a society, and the duties that these rights present for churches, for civil associations, etc. So I would like you to expand a little bit about that, because the Universal Declaration is a very substantial document, and the brilliance of the drafters really was revealed that they covered almost all aspects of social life. And it presents substantial challenges to all enterprises in society, including churches.
Well, yes. So it's a universal right. It is endowed by some means and from some source or other, unidentified. We're talking about a secular instrument here. And the Lutheran World Federation, interestingly, in its explanatory notes about the 48 Declaration, attributes the drafting of the terms of Article 18 in the UDHR to a Lutheran Nolke. Who knows? Who's the... No, Nolke is the... Friedrich right, Nelke, is it right? Okay. Well, yeah. Right, so we have this position that this right of free religion applies to everyone. The duty to respect it, therefore, which I presume is a duty which flows from the right. I've never quite understood the relationship between the claimed right to freedom of speech and that which generates the right. Is it, in a Christian sense, is it a divine gift? Or is it somehow a constructed duty to exercise this right? Is it a duty on the state? Does that duty on the state to respect it flow from the right of the individual? I'm not entirely sure. And we really haven't discussed the interplay between these two notions of right and duty as stimulus, if you like, for religious freedom. But let's assume it applies to everyone. Therefore, the duty to respect religious freedom, the right to exercise religious freedom, the right to impose limits on its exercise, and these are rights or powers of the state, typically, as conceived in the instruments, and the duty upon churches to submit to legitimate limitations placed by state law on a church's right to exercise. That these things all apply to different actors, and they are multiple actors, obviously. There's the international community, the national states, there are alliances of national states, short of being global alliances, regional alliances, and the same is mirrored in churches, of course. You have international ecclesial alliances and communities, you have regional ones, you have global ones, and one would expect there a reiteration of the right of religious freedom, the state duty to respect it, the duty of churches to respect state limitations imposed on its exercise. There's extraordinary perichoresis or dance, if you like, between the respective rights and their objects and their different objects. You'd expect something on that, but the struggle I had with all this stuff is, and you may say is rather defeatist, we have the great scholars, Christian scholars from the traditions, who are thinking about the nature of religious freedom. But then you look at the stuff that the churches are producing, and there's just a poverty to it. I'll repeat that word. There's a complete poverty to it. And all you have is this slavish mirroring of secular notions. And where is the imaginative faculty, as it were, of the churches in their official teaching, in their legal systems? Where is that imagination? It's just not there, as far as I can see. Please tell me I'm wrong, and that my understanding here is completely wrong. I'd love it if somebody said that. But that's my initial reaction to that. Multiple actors, I think part of your question is unraveling the mystery of the interplay between duties and rights here, and you know, the right of a corporate right of a church, individual rights of its members, generating or being a result of the duty of the state to respect their religious freedom, the right of the state to impose legitimate limitations on its exercise, the duty on churches to respect those legitimate limitations and so on. I think part of this and the actor's question is all about that, this structural, technical, apparently boring stuff about the nature of these rights and duties.
One of the things that I do at these conferences when I don't have anything interesting to say in response to a question is I say some things that the question made me think of that might not be responsive, but I use the occasion anyway. And so I'm going to do that. You mentioned the role of NGOs around the world and their involvement in debates and controversies about religious freedom. And it strikes me that sometimes, at least this is true in the States, in some contexts, people talk about the churches as if they are, in quotes, merely voluntary associations like any other, right? So you can imagine this civil society space chock full of these mediating institutions that Tocqueville and others liked so much, and churches are just one of those, no different from, say, the Boy Scouts or the American Association of Retired Persons or what have you. And as such, as mediating institutions, churches do enjoy various rights under our First Amendment. One of the things that happened in this 2012 case called Hosanna Tabor that I talked about in my remarks is that the justices, and did I mention unanimously? The justices rejected the idea that churches are merely civil society associations like any other. That is, they acknowledged that all civil associations have some rights over their membership and their internal procedures and so on, but they insisted that churches, by virtue of our religion clauses in the First Amendment, are different. They are, as some scholars put it in America, they are special. And I don't know enough about the international law on this matter, but it strikes me this is an important affirmation by our Supreme Court, that kind of to push back against any efforts to reduce the nature of a religious community to that of simply another voluntary association. I think that's important.
So we've only got 3 minutes left, so I think we'll have to make this last question, so I'm sorry about that. So
this is a question for Professor Garnett. So at the end you talked about the question of whether church autonomy is under threat and presented 4 reasons to worry. And one thing I found striking about those reasons is all of them refer to social and cultural shifts. And so you said that in terms of the state level in the US, things are okay or pretty good, especially post the table. But there are these cultural shifts that are occurring. And I just wanted to hear more about in what way you think those cultural shifts put church autonomy under threat. So one thing that's happening is the church might be, or churches might be less effectively playing the kind of infrastructural role you want. And that's regrettable. But that's not exactly the same as the church autonomy itself being under threat. So is the thought that the kind of trends, and perhaps especially those you talked about in your 4th category, will in the long term lead to legal decisions and the state acting in ways that do begin to undermine church autonomy? Or is there something else? I just wasn't sure why even those things you said are regrettable and things we don't want, in what way they actually put church autonomy under threat?
Yeah, it's a great question, and you stated it very clearly. I guess I am making kind of a predictive judgment that that over time, if we do see this deinstitutionalization generally, this rise in the unaffiliated, that, I mean, it's kind of a feedback loop in a way, that if persons are less invested in churches, not only will the churches become less able to play the role that I think they need to play infrastructurally, but I do worry that persons will come to see, and the word I used I think was a luxury good, they'll come to see religious freedom as kind of a thing that we extend if it's not too inconvenient for us, if we can afford it, you know. But it's not really something in which I have a stake. You know, as someone becomes more and more disaffiliated, one might cease to see the importance of recognizing the institutional self-government, autonomous prerogatives of churches, and so that's the fear. And whether that comes about, I mean, we'll see. On the one hand, the good news is when you have a 9-0 Supreme Court decision, that tends to entrench certain norms for a long time. But I do think that it's not unreasonable to worry that if the freedom of churches starts to be seen again more as a luxury good than as this kind of shared necessity like clean air or clean water, that it becomes more vulnerable.
okay, that's wonderful. Thanks for the questions, and I'm sure we want to go rousing rounds of applause to thank the speaker for such a wonderful session.